Hi, I'm Danny Hammond. I'm from the Lake of the Ozarks area of Missouri. Been living in Kansas City for a long time, really traveled around a lot. Long stories, I'm sure I'll tell them as we go along. Um, I'm used to, you know, I put always like a quote or something before the posts I did. I did articles in a post on a website. And I think I'm using the website for something else now, for same subject matter, but what I am going to keep saying for a while till I've got some more people following is that I believe that there's just too much and it's too hard to save yourself from a foreclosure after you fought it the wrong way too long, which the guys that I started with 2010, 2012, some of them are just now losing their homes. But uh, things are looking different right now, and I don't see any reason for you guys to suffer. If we already did that, but everyone's in the same position. If you're in a non-judicial foreclosure state, then um, you know they foreclose on you, and they don't have to tell anyone. They don't have to go tell a judge. They don't have to go to court. They don't have to fill anything out. They don't even have to send an intent to foreclose because we're evil. That's what I would like to see. The evil one. Um, and and so once they've done that, they've ruined your credit, and then they're going to try to evict you. And if they get you evicted as well as foreclosed non-judicially, and it's not that much different than judicial, but judicial makes more sense. It's easier to understand because it's not backwards. And like Missouri, where I'm from, the um, the whole process is backwards because they let you get foreclosed on, and they say you have the constitutional right to get go to court and get your house back. So you become the plaintiff. So you'll hear me always say foreclosing party, because I've done just as many judicial and non-judicial. It's probably, I don't know if it's identical, but it's going to be fairly close. And I don't have to think a lot different. In fact, it's even easier now that it's easier now. And it is easier now. I've won 3 times very recently. And I, you know, had 9 total for 14 years. So that's how hard it is to win. And the reason you can't win is because the deck is stacked against you. So I'm not going to go over that again. I've got 2 videos. I kind of reintroduced myself, and I've got some old ones that are on here from 9 years ago, 10 years ago, but they're still relevant. So I left them on, and I'm making new ones now. And YouTube has some new ways to do things that I believe maybe we can put together a group of, like, by subscribing, clicking notifications, liking. There's some money to be made in that, but we have to get some big numbers. And so, stick around and do those things. I don't have any way to put it up on the screen yet because I'm 10 years behind, but I can catch that up probably easily in 9.5 years. Anyway, also I wrote articles, and so I'm not, I've always done some videos, but like maybe 1 to every 15 articles or posts that I wrote. Some that went to other magazines, and they always went to the website. But I always put a quote on it. Sometimes I think they're funny, and sometimes I think they're serious, and sometimes it's like Thomas Jefferson or John Adams, and sometimes it's the great Gallagher or Emo, John Stewart. I mean, I'll just pick them up, and I do a lot of Raymond Chandler, who wrote the detective movies that Humphrey Bogart starred in. And that's a lot of funny stuff. I have some of that on there. And today I'm going to tell you that this is the quote today, and I think it's from England. I think it's very, very old, and it is that all that's necessary for evil to spread is for good men to do nothing. That is all that evil wants, is to be left alone. That has always made a big impression on me. That's part of why I'm here. Civic duty, and I don't know, maybe there's other things or whatever, but also just sense of fair play. I didn't expect anything like this to happen in my America. You couldn't have either. And if you're wondering, Did you do something wrong? Probably not. And if you're wondering, even if you did something wrong, let's say COVID, a lot of people got behind. Then they got put in modifications. Those are fake. Modifications are real, but they're law. But who administrates the law are the servicers that you guys know all about them. And there are no promissory notes. And we'll just go on from there now that I've given you the quote. I don't know who it was. England a long time ago. And I'm still having trouble saying, okay, am I going to try to read this? Or usually I'm fine. Once I get going, I just throw it and I'm all right. But we're going to start out with it. And the first thing I want to say is that you are all trying the wrong thing. And I know that because we all did it. And by that, I mean some pretty darn smart people from the 2010, 2012 era. And what we're all trying to do, we're trying to make laws fit fighting outlaws. And by definition, outlaws are hard to pin down with laws. And then if they have any help, and they had a lot, and just from one source, then there's not what we can do. But many of the same people are still trying to, from that era, are still trying to catch the outlaws using laws, and they're still trying to find that magic bullet, silver bullet. But here's what I'd say to that is it's a question. Is a law really a law if it is not enforced? In other words, no matter what you find, how good it is, and almost all the laws are still in place. The only one that really, really hurt us, and that was the getting rid of laws, the repeal by a Democrat president, Bill Clinton, and a Republican Congress. They got rid of the Glass-Steagall Finance Act of 1934, which was put together by people that didn't have, 747s to fly on. Is from the 1930s. They had come out of one world war, headed for another world war. They were a very serious bunch, and the laws from that area are pretty good. In fact, the Glass-Steagall Act kept anything like 2008 happening again for 67 years, and then in 1999 is repealed. 1999 to 2007 is 8 years. So 67 years, nothing really bad happened. Country held together by law, and without law, you had Wall Street running things, and they couldn't have done a worse job for all of us. Anyway, your deal was bad at closing. The money didn't come from the named lender on your note or the security instrument. And the security instrument is not interesting. None of this is interesting. It's an important thing to note here is that if you are living in a non-judicial foreclosure state, and I'm supposing everybody does know, but maybe not, because it's really not a topic that people should have had to learn. You should have been able to trust the lawyer, you should have been able to trust the lender, you should have been able to trust the title company or whatever, and you couldn't. But the security instrument is the mortgage. And it was the mortgage in 1872 when our best defense is Carpenter versus Longan, a good law that's in place, and they're not going to enforce it either. However, we're going to use that as the reasoning for how we are going to clobber them. And I think I've been clobbering them using things that I really first thought of in 2012, and I couldn't get judges to bite on it, but I didn't know the judges were bad yet. Once I figured that out, then I had to figure out that there's no oversight on judges. There's no one for you to complain to. If they just simply don't do the right thing, there's no one to talk to. We all tried. We tried to find them. There was no oversight. Well, let's see where that goes. Has anybody read about the Supreme Court just recently? Do we find out there's a lot of corrupt people there, a lot of good people, mostly not, that have agendas? The court isn't supposed to have any agenda. And by the way, they don't judge anything. They're arbitrators between genuine disputes. And it's the doctrine of cases and controversies from the Constitution is what we're going to follow. And Carpenter versus Longan followed it. And it has not been revisited by a Supreme Court since 1872. That's not as settled as Roe versus Wade, but it's really, really settled law in that it's from 1872 and no one's ever bothered it. So we can depend on that. Anyway, is a law if it's not enforced? Well, it's still a law. It's still probably a good law, but if you can't get a judge, hey, judge, look at this. These guys cheated. If the judge does nothing, what are you going to do? And it took me a long time because I was pretty much had faith in the jury, didn't have total faith in anything, but I thought that we were about as honest as anybody as a country, and we're not. We really aren't. Anyway, so your deal was bad at closing. The money didn't come from the named lender on your note, your promissory note, and don't get that mixed up with the mortgage or the deed of trust. Deed of trust in a non-judicial foreclosure state, they're really both a security instrument. And so what's been happening to every one of you, and if somebody hasn't, please, comment on the bottom if you don't think this has happened to you, because I haven't ever seen it done right. I've never seen it done right. I have seen as many foreclosure deals as probably anybody, including any attorney, or at least any attorney on the sides of the good guys, and so there's not hardly any of them. And I have never seen this done right against us, not one time. So all of them are wrongful foreclosures. Now, do we still owe the money? Yeah, we do. And am I trying to get you off the hook where you don't owe any money? No, but that's what's going to happen, because we talk about the promissory note. You know what the name is, but you don't know what it is, or most people don't. But the one that's really tough is the mortgage or deed of trust, and they're called security instruments, and they have one function, that and your loan has been transferred from place to place. It started with MERS, and we're not going to get into MERS because that's so screwed up and still is, that we're going to ignore it. We're not going to get into fights over little things and having an attorney, scare your family late at night, or not an attorney, the servicer, or thugs. That's not a little thing. What I'm saying is that's not going to win or lose. It isn't worth bringing up. You can't, it just isn't, it's not a winner, not a loser. It's wrong, but we're going to forget that. And in fact, your case, you'll find that I'm going to, if you call me or if you talk to me, and I don't charge for, giving you advice, looking your deal over and giving you advice. And that's just because people need that. And I had an advantage and still got beat. And I'm a real estate broker, have been since 1999. I did my first real estate investment deal at 17. And I owned a mortgage company or half of a mortgage company from 2002 until 2012, when there really wasn't much use in talking about, buying homes and things. There's no one left. Most of the people I knew that had been rich were living in vans down by the river. So I'm going to try to do this paragraph again, which is your deal's bad at closing. Your loan has been transferred, and they call it the assignment of the mortgage or the assignment of the deed of trust. And the simple defense of that is that you can't assign the security instrument, the mortgage or the deed of trust, because it has no value and it can't leave its note anyway. So the note is the essential instrument document in your deal. And even if you have a copy, it's blank with no signatures, and they aren't going to bring the original to court no matter what you do. And you can get a forensic audit to see if your loan went into one of those real estate mortgage investment conduits, and we all call them trust or mortgage-backed securities. And so think of those as stockbrokers were handling those, but that's where the money came for your loan. So your lender was really a broker, and maybe they said they were a broker, but they were told to put their name on the loan. And when they did that, they were told to do something that they couldn't do. That was against the law too. And so they found a lot of laws to break here along the way. But the main thing is that they were assigning the ownership of your loan from one to another that knew each other Um, and that's how they were moving your loan to someone else. So, and you got another servicer, and you tried to do a modification. So you had the 3 month agreement. That was for the 90-day period. If they get you at 91 days over, then they get all of the PMI, all the mortgage insurance. And they bundled those 5 or 6 times. You probably heard that. It's true. Can you prove it? No, not without a good judge. So, your loan didn't come from there. And Carpenter versus Longan says that the note, promissory note, is essential to the deal because the value that you gave is the debt. You were loaned some money, and you took the money and you gave it to someone you had to give it to for the house, or you might have, maybe you're getting an equity loan on your house and the money went somewhere else. But anyway, you got some money, it went somewhere, now it's gone. So who can prove you ever had it? That's the note. The note is the evidence of the debt, and the debt is the thing. But it's really not, like if you were foreclosed on, if you've been foreclosed already, you didn't get a reconciliation of the disbursements of the funds from the sale of your house. If you did, you're going to be the first person I've met. And again, I think I've seen about as much of this as anybody. On my website, and I'll have it on, it's on here. It's actually on this YouTube channel. Find Jessica the Forecloser, and you'll see me going to a foreclosure to hassle the auctioneer, and that's all they are. It's a trustee. Trustee's an auctioneer. The trustee has been substituted in because they're crooks. And in Missouri, millions of foreclosures, six attorney firms did them all. Yet, of the millions of foreclosures, those loans had a trustee in Missouri, and the trustee was substituted out. So there were probably hundreds and hundreds of thousands of trustees, all gone down to 6 foreclosing attorneys that were brave enough to do it. And once they did it enough times, nobody went. No one goes to their foreclosure. I went to 150 of them, and that's kind of a real number because that's how many families I've dealt with and how many people I got into court. And I couldn't win like winning, but most people that would call me at the last minute, hey, I'm getting evicted in 24 hours. Can you do anything? And I did. That I can do. I can keep you in your house for a really long time, but that's not winning to me. And I had to quit for a while because I didn't have enough money to keep subsidizing people because I lost $4 million worth of investment property that I paid cash for and had no loan. And so that was quite a concern to me and kept me a little awake at night. Like, how did that happen? I know now, but and I intend to go back too. That's part of what this is. And I think that it's going to be a money problem for everybody, because they've worn us out. They've damaged our credit. And we're going to have to get together. And I think that I could never find a way to raise money. I couldn't even get people to contribute on my site. Hey, I wouldn't put them out. Like, $25 is what I got over a 4-year period that PayPal was on my site. And then PayPal stole $1,100 from me. And I took PayPal off and I didn't notice the difference because I only got $25 over 4 years before. And that's because people didn't have money, And honestly, what are you going to do? You just read something I wrote and now you're going to go win? No, it doesn't work very well that way. So pretty much the setup here is going to be, you're going to be pro se if I do anything with you, and I don't know even that I can, but I can sure tell you, what you need to do. And you're going to be pro se. You're not going to get an attorney because an attorney is not going to accuse a judge of what I have in mind, and that is we're going to call this a civil rights violation. Deprivation of civil rights is the only really serious crime that a judge can commit that is so serious that the judge loses their immunity and becomes liable to you for a damage lawsuit, and it will ruin his standing in the community, probably lose his job, get disbarred. And there are a lot of them doing it every single day and have been for a long time. So it's not the promissory note that is the value. It's the debt. The promissory note is evidence of the debt, and the security instrument is incidental. So the note is essential. You have to have the note, and you're not seeing it right now. I haven't seen, but even, they used to lie and say they had it in a safe. The lawyers did, in a safe under the, in the floor, in their office, in a secret closet. I have heard that more than once. And it wasn't there. And I've never seen a good note. And I've seen copies, and all the copies are bad. And the judge didn't question it. So why should the judge question it? Because the burden that we all put on ourselves is that we are all trying to figure out how to prove that the foreclosing party had no right to foreclose on you because you did the modification, or you weren't that far behind, or you would have made a deal to catch up, and they didn't let you. That's the judge. I mean, an attorney can't do that without somebody helping him, and a servicer can't do that without somebody helping them. The burden was never on you to prove that they were committing fraud against you. Think about it. The word fraud means they hid it. And so nobody would have made a law before the year 2000 that something that you couldn't possibly know is what you had to find out. And none of us, I can't tell you exactly what happened. I know what happened is that stockbrokers, took your note and put it into a mortgage-backed security that didn't exist, or had been registered with the SEC but was never actually opened. And then 1 year later, and you may find this if you've done a forensic audit, see if they don't say, well, here's where it's supposed to go, but it didn't. And that's the conclusion they come to. That's what I came to. So, if the security instrument, the security part of it was called, that's the agreement from the borrower and the lender. That's the agreement they've made for what the collateral is going to be should the borrower become unable to pay. Now, none of this is set up for foreclosure. It's set up for, at the end, your documents become void once you pay them off. So you have documents to prove that you got a loan. That's for them. Then you pay them off, and then they're marked paid, and they're now just paper. And I wasn't old enough yet. My grandparents had a mortgage burning party at their house when they paid it off, out in the backyard, and the whole neighborhood was there. That's what they would just take them and they would burn them. Because they were void. Now, void is a big word in what we're about to do. So anyway, if it's just the arrangement for what the collateral is going to be, and it's going to be the house, but the note's essential, and the mortgage or deed of trust is incidental, and that means you don't have to have collateral. That's not a law. If I want to loan, $50,000 to my son, and he can't pay me back, and he's my son, I'm never going to make him pay me back. So I'll want the note so I can write off I lost some money by loaning it, but I'm not going to foreclose on my son. And it doesn't have to be your house. It's just that makes sense. You borrowed the money, and it went into the house, and the bank understands the house, and you understand the house, but it could have been 1,000 Schwinn bicycles in a warehouse, and that would be just fine. And that's what that agreement's for. But that agreement, the security instrument, the mortgage, and this isn't, it doesn't hold the debt. It doesn't talk about the debt. It's not what you're paying back. You're paying back the debt, and if you didn't have a note to evidence it, so you got the money at closing and you spent it, I don't know where it is. They didn't give it to me. Well, the note proves that they did give it to you because you sign it. The security instrument merely, keeps them from just running wild. They can only go after whatever the agreed collateral is. And so it can't be assigned, it can't be sold, it has no value, and it must follow the note no matter where it goes. So if your note is at the bottom of the Atlantic Ocean, there also is the mortgage or deed of trust. And if you want to replace it, you go down to the county, pay them $15, and tell them you want a certified copy of the copy that they that's recorded there. So that's the recording that you don't. I don't know why people stopped recording the note. They used to, but now they don't record. They record the security instrument because that says what they can use to collect if you become unable to pay back. The modification was supposed to help everybody, and it was a good law, but they gave it to that servicer and that lender that weren't really involved in your loan. That's who's enforcing it. And in fact, as the servicer probably came along way later. In fact, as you probably changed servicers several times. I call it little coupons. We all paid on little coupons. How dumb were we? Well, you should be able to count on that. And you could. So who's the burden on? Your burden was not to decide or to try to prove that they did anything to you. Your burden was to say, I don't know who this is. I never owed him any money, and I'm not in default with him now and never have been because I didn't borrow any money from him. And then you shut up. That's the shut up part. That's simple. Okay. Their burden is to, in their first filing, is to say they have an injury in fact. And that's where the strategy is the same, whether it's judicial or non-judicial. It gets confusing because they operate backwards, but it's the same. And that's, what I'm doing now is just telling you the agreement, and what the pieces are that when you send me, I've got a detailed form I want people to send me because you're going to be upset when you call me. You're going to try to remember everything that happened to you, and I don't care about it because we're going to call the case void because there can't be a case. The Constitution, Article 3, means it's the judiciary of federal. Federal judiciary is all Article 3 stuff. And so Article 3 has a doctrine of cases and controversies, which means a judge can't look at a case and he can't rule on a case because somebody filed it. The founders did not want us to have a litigious society, and hopefully we're going to get away from that now. Because it should be hard for someone to sue you. In other words, you had to have done something. And otherwise it's called frivolous, right? So isn't it a frivolous suit if you don't have a note, you didn't loan any money, and you aren't injured? Now, an injury in this case, or in this instance, is a money injury. And the only money injury that a collector of money, and by the way, there is no such thing as the right to foreclose. That's just an act of collection. That's all it is. And there have been a few courts that ruled, no. Well, they're the ones that were trying to cheat. But for the most part, it's an act of collection. And in order to collect money from me, you had to have given me some money. Now, maybe it's money that you gave me literally at closing in the real world before 1999. All you had to do was say that you gave me money, and then your note says, yeah, that did happen, and we still have the note here. It's signed, and every time that they paid, we wrote it on the note. That's what they're supposed to do. And that's all I want to make clear, really. In this is, I'm kind of been gone for like 4 years from this. I've been doing it for 14, and I tell you the truth, it's ruined my life too. Family, friends, time. A lot of time's gotten away from me, and I can't get it back. So this is something that we should all take, pretty seriously. We're not going to get into mortgage-backed securities today, but that's MERS and mortgage-backed securities, and where's the note? They got to have the note, and they can't have a copy, and they've got to also show that it's been endorsed properly like it should be. And the assignment of the mortgage, the assignment of the security instrument, the assignment of the deed of trust, all the same thing, can't be done, period. And so if yours has been done that way, we're halfway home. you know, and I haven't come to the last burden yet. So they had the burden of saying they've been injured by you, and they can prove it with concrete and particularized evidence. We go back at Perry Mason through Boston Legal, um, reasonable doubt, beyond reasonable doubt. Well, this is even tighter. Concrete and particularized is big, can't get around it, can't get over it. And here's all the details. They have to have that before they start. They can't start with just claiming you owe them money. It's that claim, and it's honestly, it's us trying to prove the claim is wrong. And it's because we had to, because the judge wasn't doing it. The judge was supposed to review their first writing. Usually in a judicial deal, it's they file a lawsuit, and the lawsuit is an evict or is a foreclosure lawsuit. And they're saying, you owe us money, you didn't pay it, you fell in default, and you have no excuse for it. And sorry, but we need our money back. And then the case goes on. They put a number on it, and then you're arguing. And none of us, I mean, like I said, I'm an expert at real estate law. I'm an expert at finance, but I'm not an expert at crime. I mean, honestly, none of us should be. So what a way to be judged. The judge isn't, and honestly, we can make up all the excuses for them. They're dumb. They don't stay up. They never learned it at all. If you're a federal judge, the reason you're a judge is you went to the right parties with the right people and got nominated by the right guys, and look where that got us to the Supreme Court. It's not a very good thing. So where we are is that we're down to, okay, your only burden is to say, I don't owe him any money. You don't have to say more than that, because you don't have to prove there was a fraud. That's what we're all doing. That's what we all did. That's what I don't do anymore, is that we're not going to prove anything for anybody. If you think I owe you money, bring your proof to me. Or really, when you file your case, it has to be already written. And the judge has to read it. And if they don't claim that they've suffered an injury, and the injury is real, injury in fact is what it's called, the injury is real, and they've got concrete particularized evidence, and it's in the lawsuit already, then if it's not there, they don't have standing. And a judge cannot make that standing. He can't decide it later. It has to exist at the beginning, or it can never exist at all. And standing, once found to be deficient, cannot be repaired. And so that's standing. So if there is no standing, the judge, when he looks, he can't find that they've claimed to have an injury in fact, and that you caused it, and that their injury is they put money either to buy your note the right way or to fund it the right way, then the judge can't take the case. He doesn't decide that. He shouldn't be called a judge. They're arbitrators. They shouldn't wear a robe. I mean, do they wear that at lunch? No. I mean, that's really not proper clothing for a businessman. A business suit would work. And they don't need those tall benches to make us all feel small either. And I'm making fun of them because I think that we can, that we can beat them. I just don't, it's going to end up being a money deal. And I've got two more still. I might end up with 5 unless I'm wrong. Let's not wait and see. Let's prepare. If I'm wrong, then we shouldn't do it. But let's be prepared to do it. So you'll want to ask questions. And to do that, I've got somewhere on this on my channel here, and I can't see it yet, and I don't know where it is because I've only been doing this again for like 3 days. I've been doing just a website for many years. So, MTG FRD, if you write that down, it looks like mortgage fraud. mtgfrd.info@gmail.com. Drop me a line. And then also I've got on here somewhere, and you will see it, and that is a form. And I did a real detailed form because people didn't know what they had. And if I ask them on a phone, do you have a note? You know what it looks like? And sometimes the conversations just get too long. And that's one of the reasons I couldn't afford it, is it just took so much time to sort it out because people don't know the terms. And like, maybe it's a Lamborghini mechanic coming to me and I've got a Lamborghini and I make fun of him because he didn't know anything about real estate and buying houses because he bought, one so far in his life and he may buy two. And if I have him work on my Lamborghini, it's because I don't even know how to get the hood open. So I'm not saying that anybody was dumb. I'm saying that you shouldn't have had to rely on him. You had the judge. You should have been able to rely on the judge. And you should have been able to rely on the lender or the title company or the lawyer that closed you, depending on what state you're in. In half of Tennessee is one way and half of Tennessee is the other. I don't know if that's because the Union Army was too long in one half. I don't know. And so anyway, that's one way. Then this detailed form I have, I don't care. I mean, I don't want anybody to labor over it and try to figure it out and try to go find it or go down to the recording office. Answer what you know or leave it blank. The blanks tell me you don't know that. And then what you do know and you can answer, fill that out. And I'll tell if you know it or if you think you know it, but you're wrong. That tells me a whole lot. And now I can talk to you and keep you calmer and actually lower your anxiety instead of raise it. And it's worked really well for me. So that's in there too. And all you do is click on it and then you have it and then you fill it out. And when you're done, click submit. And in it, you will have told me whether you want me to contact you to see if you want me to review it and tell you what you've got. And then see if there's anything we can do or anything I can do. And there may be, because like I said, these are going to be cheaper. And if I get two more to fall in a row, then I'm going to be finally confident. And I've won even some big cases. Kansas City, $2.5 million of damages in a $600,000 house. And I did it the same way. I've done them all. A $600,000 house in Kansas, which is a judicial foreclosure state. Missouri is a non-judicial foreclosure state, and there was no difference except it's harder to find a smart. Well, no, it's hard to find a smart lawyer that will do it in either state. And there's plenty of lawyers that say they'll do it. Or I got on YouTube to see what people were doing, and all the same thing. Like here we'll do a paralegal class for you or a pro se class. You don't need that. What we got to do is figure out your deal and figure out civil rights, because that's what it's all about. You have the civil right to due process. You have the civil right for the judge to watch out for you. And when the judge doesn't, this is a big crime. This is a very big crime. It's the one crime a judge cannot commit. He cannot deprive you of your civil rights. He can't do it. Okay, so what happens if he does? Then he wasn't a judge. That's the law. Only a judge can't do it, and what that is, it's subject matter jurisdiction. So standing's what the lender, foreclosing party, you're always going to hear me say foreclosing party because they're not plaintiff or defendant. That's switched in the two different kinds of states. But so the standing is for the foreclosing party. And to have standing, they have to be able to prove that they had your loan and the underlying debt, the balance of the debt. Remember at the beginning, I said that when they did your foreclosure, they didn't send you a reconciliation of the disbursements of the proceeds of the sale. Because probably if you've had your house for over 10 years, or this went on 10 years before you even got in trouble or whatever, there's no way that you owe them any money. But they'll have some big number bigger than what you borrowed in the first place. And it'll still be bigger because you've also had a gain in equity during that period of time. So your house is worth more. So they've got to make it more. And then the bidding process, and I've watched this, is a con game too, in that somebody wins the bid, that's their guy. He's only there to bid up one more time than when everybody else quits. And there's not anybody there because they all know it. None of this is what you thought it was, and that's the purpose of this conversation. First of all, nothing's like you think it was, and all of it's easier. And honestly, it's all like you think it should be. If a judge is rogue, you ought to be able to go tell somebody, and you can't. There's no one to do. other judges. They're not going to do anything. So um, I'm going to quit now, and I don't know what I'll call this, but it'll be on. Well, you don't even know this yet. So when you look, you'll know what the name is, and I will too. Danny Hammond. I'm from Lake of the Ozarks in Missouri. Long time, still have an office in Kansas City, Missouri, and I've helped people in 151 families that I got all the way into federal or state court, and never lost a single person who left their house any less than voluntarily, except me. And I knew what happened, and they hit me with, "Oh, you got to have a bond in order to appeal." Well, no, you just foreclosed on my house, and now you burned my credit up. Where am I going to go get an insurance bond that covers the whole value of my house? And I'm wanting to get even. I don't know if you guys want to get a hold of me, and we'll talk. And at least I'll lower your anxiety, and you'll have a better idea of what your situation is. I promise that. And I don't charge for the conversation. And I'm not going to try to sell you some template contracts for you to fill out and then go down and get yourself, blown out. You'll either believe that I know what I'm doing, or don't do it. That's my advice. You can't trust anybody, and you can't trust me yet. A lot of people do, but I can't let you talk to them, confidentiality. And my confidentiality is because people are too embarrassed about this. They've been robbed. It's not anything that you did. It's not anything you did. It shouldn't be a secret, and we should work together. And I think we can raise money, but we can't raise it individually. No one's going to feel sorry for us on GoFundMe. Borrowers that didn't get foreclosed on, they say, "Well, I didn't get a house for free," and I'm not advocating anybody get a house for free. The thing I will tell you is that we'll never find your note. Therefore, I don't know. You'll owe someone, and a judge can't take your house and give it to somebody that you don't owe for sure. So you should owe someone, and you'll always owe them. But there's no way that they're going to find them because they lost them on purpose. They stewed them. They sold them over and over. And every probably wild story you've ever heard, that's really what happened. Okay. Danny Hammond, and you got some information there that tells you how to get a hold of me. I'll try to do it as quickly as I can. What I'm doing now is I'm starting up old companies that I shut down because I was retired. I had $4 million. Now I have, about $150 today. Some days I have a lot more, and some days, but I've got some things I'm working on. I am kind of busy, but I have to do this because I want to enjoy my properties for a while. And I got old during this. And I didn't intend that. Okay, Danny Hammond, I'm just going to punch this off because I don't know how to do it any other way. So have a good day.